This Ninth Circuit case is about the cops creating exigent circumstances to search somebody's home without a warrant. The facts of United States v. Lundin, a 2016 Ninth Circuit case, are rather simple. A woman is abducted at gunpoint. The officers issue be on the lookout and a request for an arrest around 2 a.m. in the morning. Around 4 a.m., 2 officers arrive at the suspect's home. They come up to the front door. They knock on the door. When nobody answers, they wait a couple seconds and they knock louder. Around 30 seconds later, they hear a lot of noise coming from the backyard. So they run around and they see the defendant. They arrest him. They take the suspect, they put him in the squad car in handcuffs, and then they go back to the patio and search it. They find 2 handguns. The defendant files a suppression motion for those 2 guns because he says they were found illegally in violation of his constitutional rights. Of course, we already know that the Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Because the house is explicitly stated in the Constitution in the Fourth Amendment, there's going to be a presumption that if the cops search it without a warrant, there's going to be a presumption that this was unconstitutional. Now, in this case, the guns were found on the patio, on the backyard. But the curtilage, or the area that surrounds the home, gets the same protection under the Fourth Amendment as the house itself. To justify this search, the government is relying on 2 theories or 2 exceptions to the warrant requirement. One is the exigent circumstances, and the other one is called the protective sweep. Both of these exceptions I have discussed in my prior videos, and I encourage you to watch them, and I will link those videos at the end of this one and here above. Under the exigent circumstances exception to the warrant requirement, police officers are permitted to search the home if there's a compelling reason for them to enter into the home quickly because of the exigency. Now, the officers are not permitted to create that situation themselves. And in this case, the court says that the fact that the officers were there at 4 a.m. in the morning knocking on the door without announcing that there were police, they created the exigency. They knocked on the door, they might have startled the person living inside, thus creating the noise and thus creating the need for them to go on the patio. Now, the government tries to save their argument by saying that the officers were permitted to be on the porch and knock on the door under the knock and talk exception. Now, the way this exception works is that most homeowners gave an implied consent or an implied license for individuals to come up to the front of the door and knock to try to engage with the people living inside. That's our customs. But police officers don't get any special rights compared to normal citizens. So there's 2 problems with this argument. The first one is that officers can come up during normal business hours. It is rare that somebody comes up and tries to knock on the door at 4 a.m. in the morning. And the second problem is that most citizens come up to try to engage. Thus, it's called knock and talk. And in these situations, the officers were never interested in talking to the person inside. They were there to make the arrest. The second justification to the warrantless search of the home fails as well. The government relies on the protective sweep doctrine. Under this doctrine, the officers are permitted to do a quick search of the home incident to the arrest, meaning when they're arresting a person, another officer can walk around the house quickly to see if there's anybody else in the house that can pose danger. Now, in this situation, the argument fails because by the time the officers are searching the backyard, the suspect is already arrested, he's in handcuffs, and he's sitting in the back of the car in the police vehicle. So that means there's no reason for the officers to be going back, and there's nothing to suggest that there's another individual in the house that can pose them danger. Here's two things to remember from this case. One is that no one is suggesting that the officers can never make an arrest of an individual who is suspected of kidnapping somebody with a firearm. What we're saying is, under the Constitution, the officers should have simply called a judge and received a warrant for the arrest and the search of the home. And that would have been constitutional. And the second point is that, what does it mean when the gun is suppressed? What it means is that it doesn't come in as evidence in this case. So most likely all the charges that are related to the firearm will be dismissed. If you enjoyed this video, please click like, subscribe, and hit that bell notification button so next time I post, you'll be first to know.